I would like to say hello once again. I'm very happy and honored to be part of this webinar. My professor and mentor informed me about this webinar, and I want to thank you for that, to thank her for that very much. My name is Mirna Dzeletovic. I work as a judicial assistant at the Civil Division at the Court of Appeals in Novi Sad. Currently, I am a PhD student at the Faculty of Law in Novi Sad. Title of my PhD thesis is Legal Position of a Child in its wrongful relocation from country or in country or abroad. What I'm going to talk about today is the parent's will as the basis for decisions in cases of unlawful removal of a child from home country. Due to the globalization and modern ways of communication, parental child abduction cases are often. When the child abduction happens, the behind parent can seek the return of a child under the Hague Convention. Hague Convention on the civil aspects of international child abduction entered into force on 1st December 1983. This is an international treaty that currently has 101 contracting parties. Article 1 of this convention stipulates two objects of its convention. First object is to secure the prompt return of children wrongfully removed to or retained in any contracting state. And second object, to ensure that rights of custody and of access under the law of one contracting state are effectively respected in the other contracting states. Statistical data from 2015 from the Hague Conference on Private International Law show that there were 2,270 return applications and 382 access applications. Regarding Serbia, this convention entered into force on 27th of April 1992. Since then, in Serbia, the special act that would regulate the procedure under the Hague Convention has not been passed. Current Serbian draft on implementing the Hague Convention is titled Civil Protection of Children from Wrongful Cross-Border Removal and Retention Act. This act, among other things, determines that procedure under the Hague Convention is conducted as uncontested, and that investigative principle dominates this procedure. This act also suggests determination of concentrated jurisdiction. Currently in Serbia, central state authority is Ministry of Justice. Hague Convention stipulates several exceptions to the rule concerning the prompt return of a child. One of that exceptions is parent's will. Article 13 stipulates that the judicial or administrative authority of the requested state is not bound to order the return of the child if the person, institution, or other body which opposes its return establishes that the parent had consented to or subsequently acquiesced in the removal or retention. What does this mean in practice? This means that Hague Convention still treats removal of a child as wrongful, even though left behind parent consented to or subsequently acquiesced in the removal of a child. But court has an option in this situation. Court can refuse application of a left behind parent on the basis of will of that parent, but it is not obliged to refuse. Court can still order a return of a child even though left behind parent consented to or subsequently acquiesced in the removal. For the purpose of writing my PhD thesis, I analyzed 100 decisions of courts from different contracting states, precisely 50 decisions concerning consent of a parent, and 50 decisions concerning the acquiescence of the parent. I analyzed the decisions with the objective to analyze the existence of the exception to the rule concerning the prompt return of a child. The results of this research show that in period from 1993 to 2014, 24% of applications were refused on the basis that the other parent had consented to the removal of the child, while in period from 1991 to 2014, 28% of applications were refused on the basis that the other parent had subsequently acquiesced in the removal of the child. Statistical data from 2015 from the Hague Conference on Private International Law show that 11% of applications were refused due to the consent of the parent, and 5% of applications were refused due to the acquiescence on the part of the left behind parent. In Serbia, none of the incoming applications were refused because of these reasons. Regarding parents' will, courts since 1998 have been applying subjective tests. Before 1998, courts applied objective tests, saying that acquiescence of the left behind parent can be active as well as inactive. When the conduct relied on is active, little weight is accorded to the subjective intention of the left behind parent. And when the conduct relied on is inactive, little inquiry on the into the state of mind of left behind parent is appropriate. Regarding subjective tests that now courts apply, what does this mean in practice? This means that courts take into account subjective intention of the parent in deciding whether there has been consent or acquiescence. In court decisions, it is often emphasized that parents' will needs to be free, clear, positive, and unequivocal. The burden of proof, as with other exceptions, lies on the parent who opposes return of a child, in other words, parent who abducted the child. So, Hague Convention does not define consent or and acquiescence, leaving the possibility for court to assess in each specific case whether the left behind parent consented to or subsequently acquiesced in the removal of a child. So when somebody asks, okay, we have this exception, and what conduct will court treat as consent or acquiescence of left behind parent, we cannot give precise answer. Court decisions on this subject are very different. So there we cannot make a conclusion what will for sure be treated as consent or acquiescence. Upon studying the cases, I made few conclusions. What conduct would not be treated as parents' will? First of all, statements made during negotiations would not be treated as evidence of consent or acquiescence. Otherwise, parents would not be stimulated to negotiate at all. Also, the absence of any legal action on the part of left behind parent would not be automatically treated as subsequent acquiescent of that parent, and at last sending the child gifts or money or giving consent to the registration of a child in new school from left behind parents would also not be treated as evidence of acquiescence of that parent. Conclusion that we can make is that the results of the analysis and statistical data from the Hague Conference on Private International Law shows that the application of these exceptions to the rule concerning the return of the child in practice has been increasing, and that application of the Hague Convention is accompanied by doubts and different interpretation of the Convention, particularly those provisions that stipulate exceptions to the duty to secure the prompt return of children. We need to educate judges and lawyers about the subject matter, because parental child abduction happens. It is a fact, and the central subject of these cases is child, and we need to protect the child when the abduction happens, and we can do so only if we have knowledge, proper knowledge, how to act in these procedures.